The chronology from my paper has now been copied, and that, together with Eleanor Cronk's paper and John Laskin's paper, will be available at the registration desk for each of you at the lunch break. So please go there and pick them up. Eleanor Cronk has been awarded one of the profession's highest honors in being elected president of the Advocate Society. She's a leading counsel, has been counsel to many boards and commissions, and she's going to tell you about a subject that Ian Outerbridge adverted to, about the necessity to find a legal framework in which to set the facts and how to go about that, and law as fact-finding. You've got to know what facts are important, and often the cases will tell you. Cheaply is another question, as Eleanor will tell you.
Thank you. Good morning. As I said to Harvey a few moments ago, when I agreed to speak today, as sometimes happens, this is the first shared piece of information with you. Check very quickly and very carefully the topic that they ask you to speak on, because it was not until a couple of weeks ago that I realized that I was supposed to speak to you today on how to find the law cheaply and quickly. At least part of that has no answer of which I'm aware. The answer is I have no idea how you find the law cheaply, but I am going to give you some suggestions as to why it's important that you try, and maybe some beginning steps as to how you go about it. I don't mean that entirely facetiously. It was very difficult for me to approach this topic in any practical way, to make suggestions to you as to how you go about conducting detailed legal analysis, either in preparation for pleadings or discovery, in a way that's truly economic for your clients. Obviously, there are shortcuts that you can take, and there are beginning steps that you can take before both the pleading stage and the discovery stage, but to do it in truly economic terms today is indeed a challenge, to use the word of the 90s. So I'm going to make some suggestions about that, but I wanted to start first, if I could, this morning, knowing that you will hear, I think, shortly after me from Tom Heintzman about the details of the do's and don'ts in constructing your pleadings, and I hope strategic considerations in framing your case. I wanted to talk briefly about the basic principle, which we sometimes forget, and that is why it is so very important that you do establish a legal framework for your case, whether on the plaintiff's side or the defense side, from the outset. The importance of understanding as early as possible the substantive law relating to your client's case or to your client's response to a statement of claim, in my view, cannot be overestimated. You start always, in my submission to you, with your cause of action. There is a direct linkage between substantive law issues and the rules of civil procedure. That is the case because the rules, as you know, identify various options for processing, for carrying out your civil proceeding. But the starting point of analysis is always the cause of action. It is essential, in my view, from the outset of any proceeding, that counsel for both sides understand the substantive law that applies to the cause of action pleaded and the potential defenses thereto. The framing of your cause of action controls the entire case from the beginning. It's therefore necessary that you understand, before you complete your initiating pleadings, what the constituent elements are of your cause of action and what the constituent elements are of the full range of potential defenses. A detailed review of common causes of action is beyond the scope of what I intend to say this morning, but suffice to say, I hope, that the first step in preparing pleadings is to research and identify the appropriate cause of action to meet the factual circumstances outlined by your client, and to conduct sufficient research early on to ensure that the required elements of that identified cause of action have been evaluated and considered. I want to provide just a simple example for the context of my remarks. And the example that I chose in my paper is that of pleading a simple wrongful dismissal case. Many of the counsel in this room, and those of you who are experienced in this area, I ask to indulge my remarks, and those of you who haven't had a great deal of experience with this particular cause of action will perhaps recall that there are well-identified basic required constituent elements to the pleading of a wrongful dismissal action. And for illustration purposes, let's just talk about what they are. The case law makes it quite clear that from a legal point of view, the constituent elements include the establishment of an employer-employee relationship, the averment that it's an obligation of the employer, if such a relationship is established, to give reasonable notice of the termination of that relationship, absent just cause. That's the second constituent element. And thirdly, the termination by the employer of that employment relationship without just cause and without reasonable notice of termination or compensation in lieu thereof. This brief summary of the key elements of a wrongful dismissal claim identifies certain of the allegations which must be made in a pleading to assert wrongful dismissal. In other words, not to unduly stress the point, basic legal research before you come to draft a statement of claim, even for a cause of action now as common as wrongful dismissal claims, will illustrate for you what the hallmarks of your pleading should be. It will tell you what the key elements of the cause of action are that you must enshrine within the framework of your statement of claim. The contents of the statement of claim, of course, determine the necessary range of options for your statement of defense. It's a basic and fundamental flaw in a statement of claim in which wrongful dismissal is alleged, for example, to neglect to assert the existence of an employer-employee relationship, or, in other appropriate language, to ensure that it's clear that there is not a principal-agent relationship or some other non-employment-based relationship. So that the challenge in drafting a statement of claim for a cause of action of that kind becomes the assertion in your statement of claim of the material facts that give rise to the inference of the legal conclusion of an employer-employee relationship. Too easily, I suggest, we forget, because of the demands of practice and the more experienced we become, that it's always a useful reminder when we start to plead, when we actually do the draft, to go back to base principles and to examine what the cause of action is and what the current case law has said about the constituent elements of the cause of action. Rule 25, as you know, is the key rule for pleadings in the rules of civil procedure, and Tom Heintzman is going to talk about that, as will others, later today. But sub-rule 25.061 is a key rule, in my view, for understanding the importance of preliminary legal research and analysis at the advanced pleading stage. You'll remember that what that sub-rule says is that every pleading shall contain a concise statement of the material facts on which the party relies for the claim or defense, but not the evidence by which the facts are to be proved. What that translates to in a practical sense, in my view, is that you have to identify what the material facts are for your cause of action, which will give rise to the conclusions of law that you will be asserting to the court to be successful with your claim. That has to be determined at the pleading stage. It's important, in my view, for either a plaintiff or a defendant to know with considerable precision at the time that you construct your pleadings what the material facts are that must be proven as a matter of law to establish your claim, not just to respond to or to correspond with the recital of facts provided by your client. Sub-rule 25.062 is particularly important in the context of pleadings and in the context of remembering the importance for preliminary legal analysis. It provides that a party may raise in a pleading any point of law, but conclusions of law may be pleaded only if the material facts supporting those conclusions of law are also pleaded. And you'll remember that that's the provision under the current rules, 25.06 sub 2. Its predecessor, long contained in our rules of civil procedure, gave rise to a body of case law, largely emanating from master's courts, about the distinction between the pleading of material facts and conclusions of law. And the important distinction, in my view, is this. If you conduct sufficient preliminary research at the time that you're doing your pleadings, the case law will signal for you what you have to say in your statement of claim, what you have to say in your statement of defense, but it will also signal for you what you should be asking to your client. It's actually a barometer for you on the fact-finding investigation stage, because the case law, by its treatment of the facts on any given cause of action, will signal to you what you should be exploring with your client to determine if those facts do or do not exist in your particular case. In preparing pleadings, then, the first fundamental prerequisite is to understand the facts, and that means more than merely interviewing your client. It means, of course, as all of us know, a complete examination prior to pleading, if you can do this, prior to pleading, a complete examination of all of the documents in the possession of your client, or available or within the power of your client to obtain for you, bearing on the matter of the lawsuit. And that document review, to the extent that it's physically possible, should be conducted in a complete preliminary way before you construct your pleadings. For purposes of illustration, this distinction between pleading material facts and conclusions of law, can I return to my wrongful dismissal case example? It is a conclusion of law in a wrongful dismissal pleading to allege that an employment relationship existed. But the allegation of an employment relationship is a prerequisite to establishing the cause of action. So what do you do in your pleading? The assertions that the plaintiff was hired by the defendant on a particular date and compensated at a particular level in a stipulated position for a particular period of time are all material facts. Those can be pleaded. When they are pleaded, those material facts support the legal conclusion of an existent employer-employee relationship. So that those facts, dealt with always in the treatment of the facts in reported wrongful dismissal cases, signal in a very practical way what your introductory paragraph should be in your pleading. If the facts don't fit, and that is if your client has not told you sufficient facts to know if you can come within the required framework of proving material facts for that conclusion of law, you've got to go back to your client. And you've got to make sure that you've covered off those facts. When were you hired? What was it that you did? To whom did you report? What were the nature of your responsibilities? What were you paid? How long were you employed? What benefits did you receive? By the time you have that kind of a conversation, if you plead all of that in your statement of claim, you have the material facts that then give rise to the conclusion of law that an employer-employee relationship existed as distinct from some other type of relationship at law. And if you plead those, you are then under our rules permitted to go on to say that in light of the facts set out in the preceding paragraphs, an employer-employee relationship existed between the plaintiff and the defendant, which was wrongfully terminated on such and such a date. So what I'm suggesting to you, and I hope in not too trite or simplistic a way, is that it is important, no matter how long we practice, to remember that the case law serves two purposes. It assists us in legal argument, in the final analysis of what we will say to the court to succeed for our client, but it also serves as the blueprint to what your pleadings should say and to the research that you should conduct before you complete your pleadings. The judge's reaction to your pleadings, of course, we've all heard many times, but this is the experience of practice, is the first introduction to your case. The very first impression that a judge receives of your case derives from your pleadings. So if you have done a pleading that is tight, that is persuasive, that does not on the face or even indirectly violate or offend the pleading's rules, you've established an impression that stands you in good stead before you get anywhere near the courtroom door, before you stand up to defend that pleading or call any evidence. In the complexity of modern litigation, and given the complexity of issues that we often deal with by the time we get to trial, it's very easy to forget that what the judge takes home to read and what they read first are your pleadings, always. And that's true whether you're in the appellate forum or whether you're in the trial forum. More attention should be paid up front to how you construct that case at the pleading stage, not only because it determines really the entire conduct or context of the action, but because it does establish that first impression that you then have to live with. It's sometimes inescapable when you're asked to speak on occasions of this kind that one slides into stories that you find amusing. I'd like to share this one with you only because it happened recently, and I'll leave you to be the judge of whether this kind of a pleading would be acceptable in our jurisdiction and whether it reflects the proper analysis of the law as we understand it. In the last couple of months, I had reason to review the very first pleading document in a large multi-party negligence action in the United States to advise a U.S. client. What was pleaded was conspiracy and base negligence, but the pleading contained these kinds of allegations. And I ask you to consider how you'd prove these in the legal sense. Amusing perhaps, but how do you plead these? The pleading said, after having pleaded conspiracy against several defendants, it contained this allegation: the acts of the conspirators in furtherance of their Machiavellian plan of deception were done intentionally or negligently and always in concert. I thought that one was sort of interesting. It got my attention. Next paragraph. As they conspired years ago, so do they now. Know they no shame. Right? It gets better. It really does. You'll understand why I couldn't resist telling you this. The third one. These are quotes, right? In alleging conspiracy against an industrial trade association, it was not only that, can I go back to the last one? They footnoted that as being Ben Johnson, and there was a footnote in the pleading that said, please, with my apologies to Ben Johnson. I thought, I'm pretty sure it's been a long time since I was in English 101, but I think they've even got the wrong Johnson. The third paragraph was, in alleging conspiracy against an industrial trade association, one of the defendants was a trade association, it was asserted that this defendant, quote, furthered the conspiracy through a campaign of corporate-financed misinformation and intense lobbying against beneficial regulatory legislation. How do you prove that one? And finally, the pleading concluded with the plaintiffs urging exemplary damages to compensate for the, quote, all-consuming corporate quest for wealth and power at the expense of innocent human lives. I thought it was sort of interesting, and it did, in the context of preparing my remarks for today, lead me to think about what you really have to prove given what you've said in your pleading. You must always remember that just as it's important to get the material facts of your cause of action in the pleading, someday you're going to have to prove it. And if you've gone too far and been unduly provocative or inflammatory, that sounded like a political speech to me. It may or may not have been true of one or more of the defendants, but God help you in a courtroom if you have to plead that. And more specifically, God help you here. Now, there may be states where that's entirely common, and that'll be an education for me, but you need a little help up here if you're going to say that kind of thing. I obviously don't recommend that similar approach here, but I do suggest to you that there's two things to remember. Remember going in to get it right, to get the law right, to at least look at the case law to see what the basics are that you're going to have to prove, and then I come back as a checklist and say, you don't know at the beginning, obviously, what evidence always you're going to have to prove a particular allegation or a particular assertion, but ask yourself whether it's within the realm of reasonability that you're going to be able to do it. And if you think you can't, or if you think you've gone too far, tailor the language. You can always save the drama for the courtroom. Make sure that your pleading's tight, that you don't appear to be immoderate, that it's comprehensive, but it's not unduly provocative, because it will come back and bite you around the door. There's no doubt about it. There's well-established authority for the proposition that having pleaded the material facts, the facts should be summed up by asserting the conclusion of law that flows from them. There's an older case from the 1940s that's well known, Masters, Famous Players versus Turner, in which it was suggested, and I think this is still good law, that it is equally objectionable in a pleading simply to plead facts without mentioning the legal consequences which the party will contend flow from the existence of those facts. So to use my wrongful dismissal analogy, you don't have to plead that an employer-employee relationship existed, but you must have the material facts that give rise to that conclusion of law, or your pleading is deficient and your cause of action hasn't been properly framed. The case law under Subrule 25.062, the one again dealing with material facts and conclusions of law, established a number of other basic principles. Where foreign law is involved, there are particular rules and particular case law that you have to be concerned with. And I commend to you the cases, and I'm not going to impose on you by going through it, but I commend to you the case law that is codified in your rules of civil procedure text on the issue of foreign law and pleading. But remember that where foreign law is relevant, in particular a foreign statute, you must plead the appropriate provision of that statute or that act, fully describe what the piece of legislation is, describe what its relevance is, and the nature of the alleged breach. You must particularize that, because that's law foreign to our courts. And you must, in order to put the opposite party on sufficient notice to put them in a position to respond to your pleading, you must, on the face of your pleading, indicate the nature of the statute, the exact provision and the nature of the breach alleged. Similarly, in our jurisdiction, where a statute is pleaded, many of us who over the years have done negligence litigation, this is the predominant example, it is still wise practice, even where not required, to specifically plead the statute upon which you're relying and the sections upon which you're relying, as well as the facts which give rise to the application of the statute. So wherever there's a statutory context to the cause of action or the relief that you're seeking, plead it, and be mindful that if it's foreign law, you have to take a look at a different body of law before you complete your pleading. The art of good pleading, which Tom Heintzman will explain from his perspective in later detail this morning, in my view, is to state the matters in such a way that nothing is excluded which may be necessary in due course to your case, while at the same time providing sufficient particulars to enable the other side to respond. So the idea is to say enough that you haven't limited yourself but to ensure that you give enough particulars, not in the sense of pleading evidence, but enough particulars of the material facts to allow a response from the other side. I wanted to give you one example of why it is more than trite to say that you must conduct preliminary legal research and have a good understanding of the cause of action and the range of potential defenses and their constituent elements before you close your pleadings. And I give you this example because it was a mistake of mine, and one can always share your own mistakes. In the second or third year of maybe it was the 12th or 13th, I'd like to say it was the second or the third. It was early. In the early years of my practice, in the days when non-est factum defenses were not uncommon, in an action on a guarantee where I was acting for the plaintiff, this was in the days of specially endorsed writs, the statement of defense came in and it simply said the guarantee is invalid. Paragraph 1 was the defendant is X. Paragraph 2, the guarantee is invalid. Paragraph 3, I live in Tibet. I'd like it tried in Toronto. That was the statement of defense. I didn't know any better. I had not done sufficient legal analysis to understand that that was a totally deficient statement of defense. It gave rise to no defense known to law, man or woman, and I should have left the thing alone. Instead, of course, what I did is I moved for particulars, and I got a non-est factum defense that would have knocked your socks off. We ended up going to trial a year later. The point of it being that had I understood fully what the range of defenses were to an action, a simple action on a simple guarantee, I would have known that nothing on the face of that statement of defense, I could have moved immediately for summary judgment and obtained it absent an amendment by the defendant. So understanding the law going in dictates the tactics of your lawsuit as well as the nature of the evidence that you're going to require. The importance of substantive law to discoveries. There's two approaches, as we all know, to discoveries. The first, the purist school of thought, or what I've termed the purist school of thought, is you know your case thoroughly before you walk into that discovery room. You've conducted detailed analysis of the law, and you have detailed notes of the material facts that you have to establish or that you're interested about going into the discovery room. That's one way to approach discoveries. Many responsible counsel will tell you it's the only way. There is another practical way out there, another school of thought, and that is we learn about our case in the discovery room. And we go in with our pleadings, we go in with such preparation as we have, and we see what the other guy says. Reality to me suggests that the experience is probably somewhere in the middle. Obviously, the second course is not desirable, but that you will face it in your own practice. Sometimes that's what you will do. It should be in the middle, in my view. What that means is, in my experience, and I offer you to, I just suggest to you that you consider this, you really are very foolhardy in today's world if you go into the discovery room without having a full understanding of what the legal issues are in your case, what the case law as then current says about it, and what the material facts are as reflected in the case law that you're going to have to establish to make your case, whether it's a plaintiff case or a defense case. You must know that before you go into the discovery room. You'll hear, I think judging from the program, most of this afternoon is devoted to discoveries, and you will hear much, I suspect, about Rule 31, which, as you know, is the governing rule for discoveries. I'd ask you to think in the context of legal analysis and getting the law early and why you should do that before discovery, to consider the language of Rule 31.061, which is the rule you may remember which says, which really defines the scope of the obligation of the party being examined and the permissible scope of oral discovery. What it says is that a person examined for discovery shall answer, mandatory language, to the best of his or her knowledge, information, and belief, any proper question relating to any matter in issue in the action or to any matter made discoverable by specific other rules. And some things you know are made discoverable, for example, with respect to experts, with respect to potential witnesses. So that the two key features of that rule is the questions must be proper and the questions must relate to any matter in issue in the action. What that rule translates to is a very broad entitlement by the examining party to examine the party opposite so long as the questions are proper and so long as the questions relate to a matter that is an issue in the action. Again, how does this relate to the law, Eleanore, and why are you talking to us about Discovery 101? Because very often when we go in the discovery room, we forget to make a full list and to consider in advance those issues that we believe in your assessment of the case are truly germane to what the action is all about. And what I mean by that is, and what I commend to you to try to see if it's a mechanism that works for you, is when you go into the discovery room, have a discovery brief that includes not all the documents that you want to refer to, but an analysis of each and every issue that you believe is relevant to the lawsuit, relevant to your client's position. And on that issue identification sheet, identify what has emerged from the case law that you've looked at as being relevant to that issue, what the material facts are in the case law as reported that pertain to that issue, and what you must get coming out of that discovery room, God willing and the world being perfect, to prove that particular issue. Never really happens like that in real life, but going in that way, you at least establish the basic framework. This is particularly important in my view from the context of conducting legal research and understanding the issues that are really relevant to your case for a couple of reasons. And I wanted to talk briefly about some practical developments that have emerged in the case law and some other things that are happening out there about discovery and why I think this will become increasingly important in the future. Many of you will know that in the last several years, starting really in 1989, several judges in reported cases have expressed concern at what has been suggested to be the conduct of counsel in examining irrelevancies on discovery, in not limiting the issues, either legal issues or factual issues that should be explored on discovery, and the allegation is expanding the length and the cost of discoveries unduly. I ask you to look, for example, at a decision of Mr. Justice Steele in 1990 in Kay et al. Versus Poslins et al., in which he had to consider the conduct of counsel in the discovery room and had to deal with the opposing views of counsel as to what evidence, was relevant to the issues in the action. It was a big fight at discovery as to how counsel could conduct themselves in the discovery room and what evidence was relevant to the issues. There was fundamental disagreement as to what issues were relevant to the lawsuit. Now that happens. Those disputes are often legitimate, but there should not be such a total absence of agreement between counsel at the discovery stage as to what basic issues are an issue in the action. The purposes of discovery, Mr. Justice Steele reaffirmed, are the ones that we've heard for many years and that we were taught in our first Civil Procedure 101 course. They are, first, enabling the examining party to know the case that he or she has to meet. Secondly, enabling counsel to procure admissions which will dispense with the necessity for formal proof at trial, that is, to help your own case. And thirdly, to enable you to procure admissions which will destroy or limit or minimize the opponent's case. And as recently then as 1990, Mr. Justice Steele, and in some subsequent cases since then, has reaffirmed what has long been trite but valid law, and that is discoveries are not fishing expeditions. You must know when you go in the discovery room what it is that you're there for and what the lawsuit's really all about. The bar response to that, in fairness, is that there is a real danger in leaving a discovery room and completing your discovery without asking questions which may, as time unfolds, prove to be relevant because the specter of negligence is out there. But there's a great divide between the potential for negligence and a non-sufficiently broad discovery and spending far too long in the discovery room. So you have two features of events out there that I think are relevant to you. The first is this dicta in a number of cases which reflects a growing disenchantment by the bench with what is seen, rightly or wrongly, as unnecessarily prolonged discovery practices by the bar. Secondly, you know, of course, the constraints in terms of costs and the burden of litigation under which we all labor and that our clients are laboring under, and that is affecting the court system itself now. That has led to the creation of a special task force peopled by representatives of both the bench and the bar and the Ministry of the Attorney General to look specifically at the proposed abolition of certain discovery rights. And one of the proposals being looked at is the elimination of discovery in cases having a financial worth of less than a stipulated dollar level. So to pick a figure, whether it's $100,000, $50,000, whatever the number ultimately happens to be, should oral discovery rights be maintained, or should some limited form of written interrogatory system be introduced. That is a proposal about which no decision has been made that is actively under consideration today. It flows directly from the experience of allegedly unduly prolonged discoveries. This is a long way away, you will say, from talking to us about the law and discovery. What I'm saying to you is, if we go into a discovery room having conducted a truly detailed analysis of what the legal issues are with which we must be concerned, knowing what those issues are and having an issues identification book with the law set out before us, you won't waste time in that discovery room. You're not there to solve every case, including IBM, Apple's, and Joe Smith's while you're there. You're there to deal sometimes with the quite narrow issues that are relevant to your case. And the way to get at that, I suggest to you, is to conduct that legal research before you go to the discovery room. And remember, of course, that the rule with which I started suggests that the obligation of the party being examined is to answer any proper question relating to the matters at issue in the action. You'll see in Mr. Justice Steele's judgment in the Kay and Poslin's case discussion of something called the Semblance of Relevancy test. And in that case, he said that the test for what is or is not the proper scope of oral discovery today is semblance of relevancy. Does it have some apparent relevancy to a matter at issue in the action? If it does, it falls at the discovery stage within the rubric of a permissible question. It will then be up to the trial judge to determine whether it was truly relevant or not. There are a number of reasons why, practical reasons in my view, why you must have that kind of legal analysis done before you get to the discovery room, apart from determining the proper scope of the discovery. The second practical reason I suggest is the use of notices to admit. Whatever your individual practice and whether it is now common for you to use them, if it is not, I commend to you reconsideration of the usefulness of that device permitted under the rules. Notices to admit are underutilized. They do permit the narrowing of issues. They do permit accomplishing two objectives of discovery: obtaining admissions that will obviate the necessity of formal proof in your case, and obtaining admissions that will destroy or limit or impede your opponent's case. You can't do a proper notice to admit unless you know what the law is that you need in the discovery room, because you don't know what to elicit admissions to. Whether on the material fact side or the facts that are going to lead to a conclusion of law. The best notices to admit with which I've been confronted have been complicated reflections of an understanding of what the governing case law is. If you know what's in the cases on the issues that court's going to deal with in your case, you can frame your notice to admit on more than did he or she sign this particular document, do you admit the authenticity of the signature. You can deal with the facts that are material to proof of your cause of action or proof of your defense. The third practical reason I suggest to you why, again, this kind of detailed legal analysis should be undertaken pre-discovery, the first being to help prescribe the ambit of the relevant issues you're going to pursue. The second, to facilitate a proper notice to admit procedure. The third being to set you up for summary judgment. You can still utilize the rules as they currently stand to move after discovery in appropriate cases for partial or full relief in a summary judgment application, depending on what you elicit in the discovery room. And again, where the case involves legal issues and it isn't a pure credibility fact case, you're never going to succeed on a summary judgment application unless you've got the constructs of the legal framework for your action down before you bring that motion. So going into a discovery room, I ask you to keep three things in mind, or at least consider the utility of doing it. The first is, am I embarking on the largest lawsuit in the history of the world, or can I narrow this down just a bit so that we're all out of here by Friday? And if so, what are the issues that I have to deal with? Secondly, what do I want in my notice to admit? Try to draft it, if not physically, then in your mind before you do your discoveries. What, in the world's perfect view, would I best get out of this discovery room in a notice to admit? And thirdly, what do I need for a summary judgment application in whole or in part? What would I have to satisfy the court on to get summary judgment now? And if you know the answers to those questions before you do your discovery, all of which requires an understanding of the law, you may actually emerge with an effective notice to admit, not a bad discovery, and maybe a summary judgment application that will work. At least I ask you to consider it. I do, you'll be astounded to know, have some suggestions about how you might actually do this and save money. They're not as fulsome as I'd like them to be. You know, of course, that the place to start with this are the tried and true methods that we all learned in the traditional sense. There are many texts out there that the entire subject matter of which is devoted to analyzing the essential ingredients of common causes of action. I commend to you Douglas McKelvin's book on legal research. It's called Legal Research Handbook. It's by Douglas T. McKelvin. The site is in my paper. It is an extremely useful inventory of the databases available, the legal texts available, and the sources out there to investigate any particular cause of action, whether it's on the liability side or a damages issue. Secondly, there is, of course, as you've heard from earlier speakers, we now live in an age when you will be confronted with or perhaps utilize on a daily basis, more than Eleanore Cronk will publicly confess to knowing how to do, computer-assisted research. The problem with computer-assisted research is that it's expensive. Unless you have the online facilities at your desk, and some practitioners now do, accessing those databases can lead very quickly to considerable disbursements for your client. That's not to say that in the world we now live in that there aren't times when, in my view, you must do it. I think there are some times when you must do it. Obviously, before final argument, before you're putting your final legal analysis or memo of law together to argue your case. In my view, you do an update, you do a check on those systems before you ever go in to do your legal argument, because it's through those systems that you now learn the most current cases. I suggest a blend of the two. Unless you have a case where the client can really afford Cadillac service, and not all clients now can, some can. When they can, God bless, and if you need co-counsel, please call. But if you don't have one of those, all right, then I suggest that you take a look at the available databases and educate yourself as to which of those are least expensive for the most online time. I thought it might be the world's most boring speech if I stood up here today and described to you the various online databases that were available. So what I tried to do was put them in an appendix to the speech. What's in that appendix is a reflection of the ones that I'm familiar with that are purpose specific. There are some databases out there that will provide certain kinds of information to you for certain purposes. Their costing is very different. Their online time charges are very different. Some more expensive than others. This room, I assume, is completely familiar with and knows about the advantages of quick law. What you may not know is that entree to that system provides you with access to over 450 databases. I'm not going to tell you that I know my way around all of those. I do not, but I can tell you that it's an extremely useful, almost indispensable tool today, and that you will find, I think, some of those set out in Appendix A useful to you. The only caution that I give you in terms of getting the law cheaply, don't take shortcuts on the law. There are some shortcuts that one can take in an effort to keep costs down for a client. There are steps in the proceeding that one can do away with or elect or waive with the instruction of the client. There are some cases still where discovery is not required. There are some cases where it really doesn't matter a hoot if the undertakings aren't complied with, as brilliant as the questions were at the time they were delivered. You can take material steps in the course of an action to minimize costs, but don't shortcut on the law, because the law, from the beginning when you construct your pleadings, an understanding of that is going to determine whether you have misconceived your case or your defense from the beginning. And if you have, even in the liberal amendment era in which we live, because amendments to pleadings are not difficult to get today, usually on terms, you can get them. But even with a liberal approach to amendments, and even with a liberal approach to reattendances for discovery, if you've misconceived the law from the beginning, you're flying with one wing from the outset. If you misconceive the law going into the discovery room, you will give bad advice to your client. Your strategic decisions will be potentially quite faulty, and you will either overestimate your chances of success or be completely oblivious to some of the holes in your case. So if I had to give any practical advice, I am so bold as to say, if you're going to save money, don't save it unduly on your legal research. Make sure it's done right, whether you do it yourself or you have it done with those who are assisting you. And there are circumstances in which computer-assisted research is almost mandatory, I believe, in the litigation environment in which we're now operating. That's not to say you have to do it for every motion. That's not to say you have to do it 15 times during the course of a case, but you do have to make sure you're current, because the next guy will be. And if you have the computer literacy to do that instantaneously, I'm going to make sure I bring somebody with me when I have a case with you who's that good, because I'm not. Thank you very much. I hope I've been of some use. Thank you.
In putting together the faculty for this program, we had to consider which of the 20 top litigators at Fastons we wanted to ask to help, which of the 20 top litigators at Torrey's we wanted to ask to help, which of the top 20 litigators at McCarthy's we wanted to ask to help, and we knew that included in that list had to be Tom Heintzman, who's figured in many of the leading trials in this country, past president of the Ontario branch of the Canadian Bar Association, heading for national president of the CBA, Tom Heintzman.
Thank you very much, Harvey. Pleadings is something that's very close to my heart, so I'm very pleased to be able to speak to you about it today. It's my view that you can become a good pleader, unlike running the 100-yard dash. Some people are not born to do that, but everybody can become a good pleader. All you have to do is take the time, make the effort, and what I think is important, learn from others who can plead. Now that may mean that there are some within your firm who are good pleaders. If so, learn from them. If they're not, go and learn by reading other people's pleadings how to plead. And the subject today, I think, fits into fast and cheap litigation, which we're not all in favor of just going fast and cheap for the sake of going fast and cheap. But I suppose the present issue is, how do I prepare a pleading fast and cheap? Issue one. Issue two, how can my litigation become fast and cheap by a good pleading? So I'll try to address those subjects, and those are what I try to address in my paper. As I started off by saying, I guess I'm always amazed how little time and effort people take on pleading. As Eleanore says, it's got to be one of the most fundamental things we do, but some people take very little time in preparing their pleading. I recommend against that. So if we're talking fast and cheap, well, you've got to spend the time to do it. Fast and cheap will be the result in the long run. And secondly, one thing I want to emphasize is how important it is to make the pleading clear, because you can spend a lot of time clarifying what you're saying, and that will save you an immense amount of time and energy and aggravation in the long run. And when you read some people's pleadings, it just amazes me how bad they are in terms of English, in terms of grammar, in terms of clarity. And that's something to be avoided. What I've tried to do is really sit myself down when I prepare this paper and try to analyze how I go about preparing pleadings. I'll not say that I do it every time, but these are my fundamental premises when I'm preparing a pleading. And what I try to do is, first of all, think of the times in the action when having a good pleading is going to be important. And as they say in the first page, it's going to be important at 3 stages. First of all, it's going to be important when somebody's seeking to attack your pleading, or you're going to be trying to move on your pleading for a remedy. So right up front, it's going to be important to have a good pleading in the pleading stage. The second point at which it's going to be important to have a good pleading is in the discovery stage, because if you haven't pleaded properly, you're not going to be able to get at the facts which you want to get at to prove your case or disprove the opponent's. And finally, it's going to be necessary to have a good pleading at trial, because without it, you're going to be at a disadvantage. As Eleanore says, the trial judge is going to judge the veracity of your case. And I really say that as counsel, the veracity of your case as counsel, in accordance with the trial judge's perception of whether you understood your case when you pleaded it, and as it presents itself to the trial judge in its pleading at the time of trial. Now, what I've gone and taking those principles, those issues, those times in the action when your pleading is going to be important, I've set out for you what I guess I would call my 7 rules of pleading, like the 7 veils of Salome, maybe not well seen, but I think there are about 7 principles that if you follow every time you're preparing a pleading, you shouldn't go too wrong. And if I'd like to go through them with you. I mean, rule 1 is so obvious, but few of us do it. To set yourself as if this action was being completed and you're about to address the trial judge after the evidence. What do you want to be able to say to him in concise terms? If you had to give a short speech to the trial judge or the jury at the end of the case, what would you want to say? If you can set yourself down in that position when preparing your pleading, it'll be a good pleading, because you will set out concisely and carefully exactly what you want to say at the end. What I try to do is make a list of the things before I start the pleading that I want to accomplish. I'll draft the pleading in English and then come back to my list and say, have I satisfied my list? That's the list of things I want to be able to speak to the trial judge at the end of the case. Second, as I've already said, make the pleading clear and concise. It just, as I say, boggles me, the old-fashioned language that you see in a pleading, the incomprehensible nature of pleading, and I really believe that on motions to strike out pleadings, 3/4 of the time, it's not the failure to identify a legal issue or the failure to comprehend your case that gets counsel into trouble. It is the impreciseness, the terrible English that is being used that opens the door for the opponent to say this discloses no cause of action. So get it clear. Rule 3, plead the facts you need to secure admissions. Now, this is a matter of judgment, and I'm sure you've seen the old motor vehicle pleadings that just had everything in there but the kitchen sink. And I'm not recommending that, to just plead things that are nonsensical and are just beyond the pale. That's silly, gets you into problems. But I do recommend that you think about what admissions you want to obtain that are reasonably within your grasp. And if they're reasonably within your grasp, then plead them. Because if you don't, you're not going to be able to ask those crucial questions on examination for discovery that may win the case. And I've seen it time and time again, where an inventive pleading has opened the door to a proof that would not otherwise have been available. Rule 4, don't admit facts that you're not sure are true. Now again, this is a matter of judgment, and you'll be criticized by trial judges, or motions judges, for frivolously not admitting facts. But I have seen more counsel get into problems with respect to admissions, sloppily made, inadvertently made, that you just cannot get out of later, or that are embarrassing to get out of later, and in terms of what Harvey's directing our attention to, that are expensive to get out of later. I mean, a motion to amend your pleadings is going to cost your client, what, $4,000 or $5,000? Maybe more. So every time you admit something that you shouldn't have admitted, you're probably costing your client $4,000 or $5,000. So make sure you don't. And I believe that you should review with your client the admissions you make, because it's up to the client to say, yeah, I'm prepared to admit that, not you to say that the admission should be made. Rule 5, Eleanor has already referred to Rule 25.06 sub 2, that a party may raise any point of law in a pleading, but only if the material facts are pleaded. I think that's an extremely important provision in the rules. We shouldn't ignore the law. You know, so many people just want to forget about the law. That's not a part of pleading. We'll see the law at trial or somewhere down the road. As far as I'm concerned, if there's a good point of law to be made in the pleading, then make the point of law together with the facts that are necessary to make that point of law relevant. Emphasize an argumentative point, which is point 6. Now, a lot of people will disagree with me on this, but I think it's a point worth remembering. If you can see in the kernel of your case a point, an argumentative, maybe some would call it, a way of putting things, then I believe you should set that out, because it gets through to the trial judge and it gets through to your opponent. Now, you may want to disguise it. Maybe it's not appropriate to set it out in the pleading. There's got to be a very good reason for that, to disguise the real essence of your case. And I think a very effective pleading can be made where you take the point that really is at essence of the action and you wrap it up and you throw it in your pleading. And it can have an impact on the opponent, and I believe it can have an impact on the judge. And in that context, you can, as I give some examples on page E5, be a little bit more fulsome than you would in pleading a statement of fact. When I'm pleading a statement of fact, I just like to state the fact. The defendant's motor vehicle was traveling along Highway 5, not the plaintiff pleads that the defendant's motor vehicle was traveling along. But when you're coming to an argumentative point, providing it's well phrased and done concisely, then you can package it with that kind of an introduction. Rule 7, and again, I'm sort of getting out to the boundaries now here, but again, if you can see a motion for judgment coming either against you or you want to make, then I think you should effectively set up your position in your pleading so that you can jump from that pleading into your motion for judgment. To categorically take on the plaintiff's case and say, you know, that's all baloney for this reason. Or put your case in a way that is in effect telling the judge, when you get to your motion for judgment, here's what the case is all about. So those are 7 points that I try to think of when I'm preparing a pleading. Now, in the 5 or so minutes that's left, I'd just like to review the balance of the paper, because what I've done on the balance is sort of take some of those ideas and sprinkle them through the rules and some of the cases. On page E6, I've talked about pleading material facts and not evidence. And of course, that's found in Rule 25.06, which is the foundation of all of our rules concerning pleadings. And it's a matter of judgment, how specific you get, how many material facts you go into, how far you get into the evidence, which you're not supposed to do. But I truly believe that if you have regard to good English, good grammar, clearness, you can go a lot farther and set out more facts if you wish to do so, or less facts if you wish to do so, than you would otherwise be able to do. Your pleading will not be attacked for pleading evidence or not pleading evidence if you're clear, concise, know where you're going, understand the law, and are going there clearly. Eleanor has made the point that I deal with on page E7, that you have to have regard to the nature of the action in deciding how far to plead particulars. It may not be necessary to plead as detailed, in as detailed a fashion in a contract case, where contract law is clearly understood and you can set it out briefly, as it is in a conspiracy action. I happen to think that pleading a conspiracy action is one of the most difficult things to do if you're to do it properly and not be open to attack by a motion by the opposite side. But if you're attuned to the different natures and the different degrees of particularity that some kinds of causes of action require, I don't think you'll have any problem. Turning to pleading alternatives, which I deal with on page 8. People are often afraid of pleading alternatives on the grounds that, well, if I plead an alternative, I take away the thrust of my primary point. I happen to completely disagree with that. Pleading alternatives shows that you are attuned to all of the issues and is the best approach unless there is some very good reason not to do so. What was the name of the case in Texas, Harvey, where they didn't lead any evidence as to damages because they were afraid that they would, the Texaco case, and Pennzoil. And I guess it was Texaco that didn't lead any evidence as to damages because they didn't want the jury to think that they were weak on the issue as to whether there was a contract, a fatal mistake. They should have put in some evidence as to damages, obviously. And the jury was left with only one alternative, namely the plaintiff's estimate of damages of $3 or $4 billion. The same applies in pleadings. If you have an alternative position, for heaven's sakes, put it forward, unless there's some very good reason not to. As I point out on page E9, if you don't put out an alternative position, if you don't put out an affirmative defense when really secretly you're relying upon one, you may not be able to put it out later. And there's some cases I've given to you where courts have precluded parties from relying on an alternative affirmative position when it was not pleaded. I won't say much about amendments of pleadings. I happen to believe that you've got to fess up to amending your pleading early. If you've made a mistake, then get about amending it. Because if you don't, you're going to have your opponent saying later on that he's been prejudiced or she's been prejudiced, that a limitation period has gone by, etc. So I think, subject to not repetitively amending your pleading, if you see a mistake, get about amending it fairly quickly, because usually earlier is cheaper. Multiple claims. I won't say much about the obvious necessity to include and think about multiple claims, other than to draw your attention to the case referred to at footnote 22, which I introduced by saying, the failure to join all proceedings in one action may result in a party being barred from thereafter asserting a claim reasonably related to the one already adjudicated. That's a principle, and that case is a very instructive one, a maritime case where a defendant in effect was precluded from later suing over against another party, i.e. bringing a third-party claim which he ought to have brought in the main action. Because the court said, the English court said, I'm sorry, we try things once around here. If you should have included it in the main proceeding, you didn't. We're not going to have this matter dealt with again. So it's very important when you're pleading to think about getting everything into the one action. If you don't, you may be precluded from relitigating afterwards. So when you're thinking about, well, I don't really want to bring that third party in, just going to complicate my case with the plaintiff, think about it. You may be precluded from doing that later. And a solution to that may be to enter into an agreement to arbitrate with that potential third party, but just leaving it hanging may be a real problem. I want to then turn to page E13, and I appreciate that time is running out, Harvey, but I want to touch on I have given to you some cases and whatnot dealing with the three grounds upon which you can move after pleadings. To strike out on the grounds that, or to move on the grounds that there's no cause of action, to raise a question of law, and on the basis of summary judgment. And I don't want to go over the materials I've set out there. I do want to touch on the 2 points that are dealt with on page E13. The first is that you should remember that a motion of this nature may result in res judicata. And I've given you a case from the Supreme Court, but there are many others, where a point determined on an interlocutory motion was held to have been res judicata and no longer open for determination or review later in the action. So if you bring a motion of this nature, it may be that you will forever determine that point in your litigation. So make sure that the way you frame your motion doesn't cause that if you don't want it to occur, or that you think about the risk of that occurring if you decide to proceed with the motion. The second point is the obvious one, which we're all aware of, that bringing this kind of motion can educate your opponent. And these kind of motions, in my view, should not be made unless there's a very good tactical reason for doing so, or that the defendant or plaintiff, whoever you're bringing the motion against, cannot amend to escape the thrust of your motion. So unless there is some very good reason for bringing the motion, or unless the person cannot escape from the thrust of your motion, it seems to me that you're not well advised to bring the motion, to bring one of these motions. Harvey, I think the rest of the paper goes without saying. I just want to deal finally with the last page of the paper, and that is the New Limitations Act, which may come into effect. And the New Limitation Act raises new grounds for deferral of the limitation period and raises issues with respect to when claims have been discovered and when claims do not run because of incapacity, etc. Now, I draw that to your attention because we will have to address our minds to pleading this new act. And we will have to address our minds to pleading when causes of action were discovered, or to incapacity, and to all of the issues which the New Limitations Act addresses. And indeed, present limitation periods do, but I think we'll just have to be a little bit more careful with the New Limitations Act setting a 2-year limitation period and otherwise sort of throwing the ball up in the air and saying, okay, litigators, find out, if you can, when the limitation period really started, to address that issue in your pleading, to address it so that you can be successful in using your pleading, perhaps for a motion for judgment, or to defend against the other person moving against you for judgment based upon your pleading or failure to adequately plead the limitation period, but more particularly, to be ready at trial to adequately address these complicated discovery and incapacity rules that will probably have to be determined at trial. Thank you.
I take it what Tom is saying is that when you peel off his 7 bales, underneath you'll find a solid body of evidence. Tom, let's spend a couple of minutes on hard practical advice. You're sitting at your desk drawing a pleading. What have you got on the desk? Do you start with a precedent? Do you have a junior do a first draft or a student? Do you have some sort of piece of paper you start as a precedent? Do you start with a blank pad and brainstorm?
Well, first of all, I will have something in front of me that sets out the facts as I understand them. I think you can't start doing a pleading unless you've got some idea of the facts. So it'll either be an interview by the student with the client, or it'll be the client's letter telling me what it's about. There's something there that tells me what the facts are on a piece of paper.
And then what do you do?
And secondly, I've got a memo of law. In almost all cases, I'll have, the law will be very clear, or I'll have somebody, be it myself or somebody, who's prepared some law. I can't think of any pleadings that I've done that doesn't have some legal issue that I want to go and look at. Those are the 2 things that are on my desk.
Right, and then do you dictate? Do you write out by hand? What's your process, your physical process?
My physical process is to, as I say, I make a list of the things I want to identify. Then I write out by hand the nature of the allegations. So I will not necessarily write out the paragraph in the pleading, but it's akin to that. And then I will dictate from that. So I will have a list. I will then prepare sort of a draft format of the pleading without using pleading language, and then I'll dictate the pleading. But I will say to you that I go through several drafts of that because I find that dictation results in too much being said. So I will try to cut back, simplify what has been said by me on the tape.
Good, thank you.
Okay.
I have a similar approach. I think there's a problem among a lot of the members of our profession of dictaphonitis. You pick up the dictaphone and you start talking without organizing your thoughts. I think it's crucial, at any stage, whatever you're doing, pleadings, discovery, whatever, to sit down with a blank piece of paper and record your thoughts. Sometimes I'll do that without anything. I'll have the list of issues and the law and so on. I'll put them aside and I'll just brainstorm with myself without being influenced by that. Just a second view and write out the thoughts. What do I want to do? And then I might draft a few paragraphs and then I'll pick up the dictaphone. Don't start with the dictaphone. David Scott has kindly agreed to come out of order. David was going to be our wrap-up speaker. At the end of the day, after we'd done production, discovery, pretrial, he was going to finish with post-pretrial, getting the facts and trial preparation. And then, as I said, Bob Armstrong got hung up on a trial, and Dave kindly agreed to rescue us and come in and give his paper now. Dave has carved himself a national reputation as one of Canada's leading trial counsel, and I'm waiting to hear what he's got to tell us. David?
Thank you, Harvey. If you can hear me, I think I'm going to use this machine, if I might. If you have a pedantic subject, use visuals because they add to the entertainment factor and mask how ordinary, everyday the subject matter may be. As Harvey has suggested, you now have to leap ahead to the assumption that you're deep in the preparation for trial phase, and my paper basically consists of a checklist of things that you might want to consider, and I'll go through it using some visuals, if I might, which are essentially in the paper, so you don't really need to worry about notes or anything like that. The paper is called Getting the Facts, but it's really getting, assembling, and presenting the facts. Getting in the sense of notices to admit, assembling in the sense of affidavits and notices, pretrial notices, and presenting in the sense of books of documents, etc. Therefore, these are some of the factual or evidentiary things you think about in preparation for trial. Let me see if this works. Attendance of witnesses and compelling production of documents for trial. This is obvious. Issuing subpoenas, which you will, of course, do for not only the attendance of the witness, but focusing on the situation where the witness doesn't attend. The original documents cannot be necessarily compelled, where certified copies will be adequate under Rule 53. And it's interesting that if you are faced with an order quashing a subpoena at trial, you can appeal even during the trial process. Secondly, preparing to tender the evidence of the opposite party by reading in discovery. Obvious points: ensure that the original transcripts are available for submission to the trial judge, and consider whether you wish to subpoena the opposite party, including an officer, director, or partner. That may be done under Rule 53, but you're required to give 10 days notice to the opposite party, the party affected. The opposite party cannot be called as a witness in the event of an undertaking of counsel to present the witness. In other words, you cannot insist on developing the evidence out of sync. If you do call the opposite party, a rather unusual event in a trial, although you may call a director or representative of the opposite party, you're entitled to cross-examine. Leave to tender evidence taken extrajudicially. This sometimes happens, that is to say, commission evidence, and you'll want to remember in this process that where the evidence of a witness who is a party has been taken before trial extrajudicially, leave is required to tender the transcript, and the availability of the witness is the criteria for whether leave will be granted or not. And where the evidence of the witness who is not a party has been taken before trial, extrajudicially before trial, the witness may not be called at trial unless the trial judge grants leave. Then documents admitted in evidence without further proof, and there are a whole list. This is largely under the Ontario Evidence Act and the Canada Evidence Act, but a useful checklist, such matters as letters patent, the proof of public documents, proofs of proclamations, regulations, corporate records, judgments, both foreign and domestic, notarial acts, official notices, etc. Then evidence by affidavit, something that arises in our practices from time to time and is important. The rules under specifically Rule 53.02 contemplate tendering evidence by affidavit with leave, for example, when a party has died. Leave will not ordinarily be granted where the evidence is vital or is contested and cross-examination is required. Again, notice must be given of your intent to prove evidence by affidavit. Then you can also prove evidence. You can prove entries in federal or provincial municipal records of accounts. So government records may be proved by affidavit under the Ontario and Canada Evidence Act. Financial records from banks and other financial institutions may be proven by affidavit, again under the Evidence Act. And then proof of facts of non-issuance or issuance in official government records and proof of records kept in the ordinary course of business may all be proven by affidavit under the Ontario and Canada Acts. Documentary evidence admitted only where notice requirements are complied with. So you may be able to tender documents without formal proof as a matter of factual evidence, but you may have to give notice either under the Evidence Act or some other statutory regime. Thus, the obvious one, Section 52 of the Ontario Evidence Act, medical reports, 10 days notice is required to the opposite party before by providing a copy of the report, etc. Business records maintained in the usual and ordinary course of business are admissible without further proof, but again, 7 days notice is required before that process is taken. Proof of certain business records, for example, letters, orders, receipts, etc., may be effected by providing copies. Again, notice is required. And then there are a whole raft of types of documents that can be proven but by producing certified copies, such as judicial documents, bylaws, etc. But again, notice must be given, and then registry office documents. And then completing the requirement for notice is the requirement that expert evidence under Rule 53 must be noticed within 10 days of trial. Otherwise, the expert, that is to say the viva voce evidence, may not be called. And then documentary or viva voce evidence admitted only with leave of the court. So in this situation, you're talking about evidence, documentary or oral evidence, which may require leave before it can be tendered. For example, records of a financial institution which are provable by affidavit. You cannot call an officer of the financial institution without the leave of the court. For example, if you have the bank records and you can prove them under the Evidence Act, you can't call an official of the bank without the leave of the court. A party can apply to the court for leave to inspect and take copies of the records of financial institutions. And then again, in the case of a doctor with a medical report where notice wasn't given, the court can waive the notice requirement on an application for leave. For examples where the situation may change in the course of the lawsuit, leave may be granted at trial to utilize a document not produced on discovery. So if you have a document that you want to prove at trial in preparation, you'll want to serve a notice of intention to seek leave to file it. The same where you've claimed privilege with respect to a document, but have now decided that you wish to produce it, you'll need the leave of the court. If you want to tender evidence that was objected to on discovery, that is where you have made an objection to evidence tendered on discovery, you'll need the leave of the court. The same with evidence that was not corrected on discovery, and again, the evidence of an expert where the report was not served within the requirements of the rules. Now, the important subject under this head of preparation for trial is the request to admit facts or documents, Rule 51. Eleanor Cronk mentioned this, and both Eleanor and I, and perhaps others, were at a dinner in Ottawa earlier in the week when Mr. Justice Major of the Supreme Court of Canada talked about litigation and the abuse of oral discovery. And he suggested that the request to admit facts or documents under Rule 51 was a process that will ultimately be imposed on litigants. In other words, whether it's in the form of interrogatories or this kind of a notice, at the discovery stage, its importance cannot be overstated. But in preparation for trial, this is where you dispense with formal proof or indeed arrange for proof that you might not otherwise have. The rule has many deficiencies, and that's, in my view, why it is not used to the extent that it should. It's intended to secure admissions as to the truth of facts or the authenticity of documents, and all of you have no doubt used the rule, so you know what it says. It needs to be responded to, that is to say, a notice needs to be responded to within 20 days, and if you don't respond, if you simply don't react, then you are deemed to have admitted the truth of the facts or the authenticity of the documents, and the ramifications of that can be serious because a statutory or an admission under the rules as to the truth of a document cannot be withdrawn lightly, and indeed there are cases which establish that it ought not to be permitted to be withdrawn. So you will be deemed to have admitted if you don't reply at all. So when you get a notice to admit, be sure to reply either by denying the truth of the allegation made, or in effect setting out the reasons for refusal to admit, either that the question is not, or the assertion is not properly cast, or as it may be. Now, the weakness in the rule is that its force depends on a costs order. In other words, if you're forced to prove facts which you sought to have the opposite party admit, then the trial judge can award costs as an expression of the inconvenience to which you've been put. And you can see, since notice to admit can be served at any time in a lawsuit, if the only lever is after the lawsuit is over, the practical advantage of the rule is lost. And I would expect at some stage in the process of trying to cut down discoveries, this rule is going to be changed. For example, why should we not be able to serve a notice to admit before discovery, and if we don't get an admission, and get the admissions on discovery, and have the costs directed to be paid forthwith after discovery, rather than having to wait until the end of trial, and there may, of course, never be a trial. The request can be served at any time, which is important, and while this is not part of the pretrial process, it's useful to remember for summary judgment. As I indicated, while there is a provision for withdrawal of an admission, it is extremely difficult under the rules, and I've cited a couple of cases in the paper which demonstrate that if you've deemed to admit or have made an admission, it will be difficult to impossible to withdraw. Another point which is not always apparent is that on notices to admit, you cannot challenge the relevancy of the question of fact which you've been asked to admit. In other words, relevancy is presumed, although this seems somewhat draconian, and I would doubt in a particular case if it would necessarily follow, but that's the current state of the jurisprudence at the moment. Insofar as documents are concerned, the rule doesn't really work at all, because it says that you can be required to admit the authenticity of a document, and the word authenticity, as I've indicated in the paper, speaks of truth or authorship or validity or genuineness. So there's simply too many, it's simply too vague a word, and there are too many ramifications that can be read into it to permit other than the most obvious document to be admitted. And the forms provide for the form in which the notice to admit should take. So if you are serving a notice to admit facts, the important thing is to be very specific and not general about what it is that you wish to have admitted, so that the opposite party cannot escape. The same with documents. You want to be sure that you have a specific and clear indication of what it is about the document that you want admitted, not merely that it is authentic, which has too many options to escape, but rather that it was dated on the date that it is given, that it was signed on that date, that it was signed by the parties, or whatever it may be as required in your case. Now then, let me just conclude by saying a bit about presentation at trial. And the paper refers to two things. The first is the book of documents, which is used in almost every trial, whether it is a relatively straightforward trial with few documents, 10 to 20 to 30 documents, or a complicated trial with hundreds or thousands of documents. Someone has got to prepare the documents from the admitted ones, and it's my practice to try and be the person who prepares this book. Because if the book is prepared well and is useful, first of all, you will get credit as the party that prepared it from the trial judge, if only subliminally. Secondly, if you prepare the book, you can do something about how the documents are ordered. So I always try at the pretrial stage, conference stage or whatever, to volunteer, quote unquote, to do the book. You can do it to the advantage of your client. You want to have an understanding as to what is being said about these documents. We've all had trials where there is an attempt at the moment of commencement to produce the book of documents, and nobody seems to know what it is that's being said about them. If I have the book of documents and I hand it up and I say, these documents are admitted, I can guarantee you my opponent will get up and say, well, they're admitted in a certain sense, my lord, but they're not admitted, and the next thing you know, you're into a debate as to what admission is being made about them. Books of documents at trial are of no value if in the course of the viva voce evidence, they individually have to be proven. So what you want is some form of admission of the documents so that they can be marked as exhibits without more. The trial judge can have reference to them whether or not they are referred to in the evidence, and this requires some negotiation before trial. What you want is an admission as to their genuineness, leaving it open to the individual witnesses to cast particular gloss on what the documents may or may not mean. Now, what do these books look like? Everybody's done hundreds of them. This is extremely pedantic, but for example, you probably can't even see that, but it's a table of concordance, and basically what I'm saying is you have the tab numbers in the book, the dates, a description, and then as Harvey indicated in his opening, speaking of his chronologies, you have a reference to the discovery exhibit number, whether it's a plaintiff's document or a defendant's document, a space for a trial exhibit number, and my habit is when you have a lot of documents, it's a good idea to make up in a separate bound volume a copy of the index, and you give it to the trial judge, and then he can use that as a working document. He can put his trial exhibit numbers in there as they are marked, and you can even have a space for notes so that he can use this as a book that leads him through the documents during the course of trial. And this, of course, provides great credit for yourselves as the author of it. Now then, there isn't enough room on the screen for this, but this gives you another example of a type of document book, which again shows the exhibit, whether it's a plaintiff's production number, then the discovery exhibit number, and any undertaking or other references that may be appropriate. And lastly, may I conclude on the subject of presentation by endorsing our chair's reference to chronologies. The most underutilized item in my experience is the chronology, and lawyers have a tendency not to use them and indeed go into elaborate analyses of the facts without the use of a chronology for the trial judge at trial, which is extremely confusing. No document is more welcomed by the trial judge than the plaintiff's chronology, which is offered as part of his or her opening. And again, it's very simple. There are many versions of it. This one just says chronology at the top, chronology of events, and it gives them the dates and then a reference to what happened. Certain shares were issued, work was started on a particular project, work was concluded, a guarantee was signed, and the exhibit numbers are all given. If you hand that to the trial judge, I will guarantee you, in the more complicated the trial, the more it will happen. The trial judge will constantly be referring to the chronology. As you watch the evidence going in, you can see him flipping over. It's a very useful thing, and it's something that you should be sure you do, even if your opponent does not. There are other versions of the same thing. with a little more detail. Here you have the date, and then the description of the event, and a little more detail as to where he can find the document, whether it's in an exhibit, or in the document book, or in some particular piece of evidence. Lastly, let me say this. My experience is that it is not productive particularly in a complicated case, to try and get your opponent to agree on a chronology. Because, of course, there's never agreement entirely between the parties as to what the events necessarily are, and certainly not the events that are relevant. And I find that if you insist that you and your opponent agree on a chronology, then you'll end up with a document that is too unwieldy. Now, there are no doubt exceptions to that, but my use of a chronology is as part of the opening. I make sure that what I put in there is scrupulously accurate. I make it clear to the court that there are other events that my friend may think are equally relevant, but these are my events. And again, as I say, if you do it reasonably fairly, don't omit significant events that the trial judge will be interested in. He or she will use your chronology, which at the end of the day will be to your advantage. Thank you.
A variation of that is if your opposing counsel will only agree to some of the facts in your chronology, but you intend to prove others, you can present the judge with a chronology that uses one typeface for the agreed facts and, say, italics for the disputed facts. And you say to the judge, plain type is agreed, I intend to prove the ones in italics, but they're not admitted. Sapinka killed me at a trial with a document book, and in his opening went through the documents and read from excerpts from the documents, from the document book in his opening. I was dead before he called his first witness. I've stolen that technique now. I always read from the document book as part of my opening. You're going to hear a reprise of this afternoon from Melissa Kennedy and Mr. Justice Lissaman, who are going to talk about trying to knock heads to force agreement on an agreed chronology, an agreed document book at the pretrial, failing that on the eve of trial, and that'll be interesting. Thank you very much. We'll see you please back here promptly at 1:30 if you can, inside. Remember the documents to pick up at the registration desk, the additional material.